Welcome to the Bald Brad Show. In today's episode, we have breaking news that the Supreme Court has struck down New York's concealed carry law. Now, before we jump into the background, the highlights of the case, the opinions, the news and information you want to know about, support the show by hitting that like and subscribe button. Your help would be greatly appreciated. With that being said, this was a major victory for Second Amendment and gun right advocates all across the United States. This was probably the biggest victory we've seen in terms of gun rights since the Heller decision back in 2008, over a decade ago. And what I would like to do in this episode is, before we jump in the opinion itself, is go over a short background and synopsis of how this case got to the Supreme Court in the first place. So in summary, you had these two guys, Robert Nash and Brandon Koch, going in and applying for a concealed carry firearm license for the purpose of self-defense. And while their paperwork was being reviewed, you had the licensing officer denying both of their applications because they found that neither of them met what was called a proper cause standard according to New York law. And if you're listening to this, I put proper cause in air quotes. And you might be wondering, what the hell is proper cause? I've never heard of that before. According to New York law, it's to demonstrate a special need for self-protection distinguishable from that of the general community. Now, if that sounds asinine, that's because it is asinine. You got a bunch of lefties that put this stuff through because they don't want people to have firearms. That's really what's going on here. The left doesn't want Americans to have firearms. And these two guys saw right through all that red tape and they go, well, this is a bunch of hubbub. So they filed a suit in federal court for violation of their Second Amendment rights. Now, as you'd imagine, New York's a leftist state, just like California, Massachusetts, New Jersey, all these other places. And it was struck down. And so these guys took it to the Supreme Court. And that's where we get the case New York State Rifle and Pistol Association Incorporated versus Buren. This was heard in October, and now we're getting the ruling today, June 23rd, as of 12:03 p.m. The Supreme Court today struck down a New York handgun licensing law and required New Yorkers who want to carry a handgun in public to show a special need to defend themselves. The ruling was 6-3 and was written by Justice Clarence Thomas and is the court's first significant decision on gun rights in over a decade. In a far-reaching ruling, the court made clear that the Second Amendment's guarantee of the right to keep and bear arms protects a broad right to carry a handgun outside the home for self-defense. Going forward, Thomas explained courts should uphold gun restrictions only if there is a tradition of such regulation in U.S. history. And there's not much regulation in terms of when the Constitution was made. You have citizens carrying handguns, commonly held handguns, all across the colonial times, the 13 states back then, and going forward into the expansion of this country. So the left are screwed here, and trust me, they are losing their minds. Their heads are spinning. The state law at heart of New York State Rifle and Pistol Association v. Buren required anyone who wants to carry a concealed handgun outside the home to show proper cause for the license. The New York courts interpreted that phrase, again interpreted, of course, to fit their narrative, to require applicants to show more than a general desire to protect themselves or their property, which goes against that natural right that was given down. Now, natural right, when we hear that term, that is what you can look at within nature itself and be able to find, something that God created himself. So if you look at animals, to make this very simplistic, animals will protect themselves, their family, and their property. And that right was given to human beings as well, and that's what we use with firearms to protect ourselves, our family, and our property. And so if that was something granted down, you can't extend that into finding a general purpose for you to defend yourself when it was already there in the first place. In a nutshell, this is basically the government saying, hey, you know what? You meet our requirements. We're going to grant you this right now to bear arms. You can't do that. That right was already there in the first place. You can't extend that for now you to give an authority down from some overarching power, meaning the government, the state, and going, oh, you know what? We'll let you bear arms. It doesn't work that way. And now they're being called out for it. So instead, applicants must demonstrate a special need for self-defense, for example, a pattern of physical threats. Several other states, including my home state of California, you have Hawaii, Maryland, Massachusetts, and New York, impose similar restrictions, as do many cities and counties. I know in California here, if you live in Los Angeles, I just did a firearm training with my buddy. It's virtually impossible in Los Angeles to get a concealed carry license. Orange County, better chances because you got different people in place. But it is ridiculous that these states have gone this far in inhibiting law-abiding citizens from protecting themselves, which is their God-given right. It's very frustrating. The lower courts upheld the New York law decision and challenged from the two men whose applications for concealed carry were denied. Although U.S. history has at times placed some well-defined restrictions on the right to carry firearms in public, Thomas explained there was no tradition of a broad prohibition on carrying commonly used guns in public for self-defense. Damn right, Thomas. Damn right. And with rare exceptions, Thomas added there was no historical requirement that law-abiding citizens show the kind of special need for self-defense required by the New York law to carry a gun in public. Indeed, Thomas concluded, there is no other constitutional right that any individual may exercise only after demonstrating a government officer's some special need. Meaning you wouldn't have to go in to use your Second Amendment rights to get some sort of special privilege and show them proof and proof that you need to be able to utilize your First Amendment rights of that free speech or whatever it is. Amazing. Amazing that this is the type of stuff that we have to go through, all these loopholes, and get it held by the Supreme Court or listened to by the Supreme Court just to be able to use our Bill of Rights. This is how far we've gone as a nation. It's not a good thing, folks. The more laws and regulations that are put in place shows that the society is collapsing, that it's disintegrating. So the more laws you have is not a good thing. The less laws you have show that you have more law-abiding citizens that don't need those laws in place to be able to follow the law and act moral and act accordingly. So in an opinion joined by Chief Justice John Roberts, Kavanaugh contended that Thursday's ruling will not bar states from imposing any licensing requirements. There are 43 states, he noted, that use licensing schemes that include requirements such as background checks, firearm trainings, and check of mental health records and fingerprinting. Such schemes are objective, Kavanaugh explained, rather than granting open-ended discretion to licensing officials and requiring a showing of some special need apart from self-defense. Yet Stephen Breyer dissented in an opinion, of course, joined by Sonia Sotomayor and Alina Kagan. As you'd expect, these three are always left-leaning, arguing that the question before the court was the extent to which the Second Amendment restricts different states and the federal government from working out solutions to gun violence through democratic processes. Breyer faulted his colleagues for striking down the New York law without a record that would allow it to determine how the New York scheme actually works in practice, without considering the state's compelling interest in preventing gun violence and protecting the safety of its citizens, and without considering the potential deadly consequences of the decision, which extends far beyond what is being discussed here. What's being discussed is somebody has the right to protect themselves, and they're extending this into, well, what about all this gun violence taking place? Yeah, exactly. If there's all this gun violence taking place, doesn't that kind of hurt your whole ruling or your decision, your dissenting opinion of the fact of, hey, we're not going to allow people to defend themselves because there's all these other people going around shooting up places? And I'm not even talking about mass shootings at schools. I'm just talking about everywhere. Look at these gang-ridden areas in the inner cities. You're walking on the riverbed in California, you got all these homeless people acting like crazy, trying to stab you, beat you with hockey sticks on Venice, all this crazy stuff. So it goes against their whole narrative of like, oh, well, there's all this gun violence happening. Shouldn't we stop law-abiding citizens from having guns? It's so crazy. These are people in the Supreme Court. I'm not even a freaking justice, and I can read through all this crap. But that's not going to stop the left from continually trying to do this type of stuff where they're trying to knock down and regulate our rights to defend ourselves most explicitly. So that's what took place today. You're not going to find a ton of restrictions going back in U.S. history because there wasn't a lot. And I love this opinion that you had from Clarence Thomas. The left are losing their minds. You already have the governor of New York losing her mind, and this is what she had to say about this ruling.
As governor of the state of New York, my number one priority is to keep New Yorkers safe. But today, the Supreme Court is sending us backwards in our efforts to protect families and prevent gun violence. And it's particularly painful that this came down at this moment, when we're still dealing with families in pain from mass shootings that have occurred, the loss of life, their beloved children and grandchildren. Today, the Supreme Court struck down a New York law that limits who can carry concealed weapons. Does everyone understand what a concealed weapon means? That you have no forewarning, that someone can hide a weapon on them and go into our subways, go into our grocery stores like stores up in Buffalo, New York, where I'm from, go into a school in Parkland or Uvalde. This decision isn't just reckless, it's reprehensible. It's not what New Yorkers want. And we should have the right of determination of what we want to do in terms of our gun laws in our state. If the federal government will not have sweeping laws to protect us, then our states and our governors have a moral responsibility to do what we can and have laws that protect our citizens because of what is going on, the insanity of the gun culture that has now possessed everyone all the way up to even to the Supreme Court. I'm prepared to call the legislature back into session to deal with this, and I'm sorry this dark day has come. That we're supposed to go back to what was in place since 1788 when the Constitution of the United States of America was ratified. And I would like to point out to the Supreme Court justices that the only weapons at the time were muskets. I'm prepared to go back to muskets. I don't think they envision the high-capacity assault weapon magazines intended for battlefields as being covered from this, but I guess we're just going to have to disagree.
So obviously they're all going to be up in arms about this. And this is just with gun rights. Can you imagine when the Supreme Court rules on abortion, where the left is going to go? I don't know in their headspace of where they're going to go, because I just did a video the other day and you get a bunch of lefties coming in the comments losing their minds because I showed a few people of the left losing their minds on TikTok. They're going, oh, you're going to only use 2 people to sum up an entire party, an entire group of people. Yeah, because that is a great synopsis. That is a great summary of where the left have gone. And now you got them in the streets. Now you have them in front of the Supreme Court, in front of the justices' houses, yelling at them, threatening them, twerking in front of them, flashing their tits everywhere, throwing blood and puberty stuff, or period blood all over them, all this crazy crap going on. Yeah, I'm going to sum up those 2 people in that one video. If you haven't seen it, go over and support it, because they're going over and disliking it like crazy. It's nuts, and it's so funny because they're being poked and pried over their beliefs and their narratives that they're pushing on the American public. So there you have it, folks. We have a major victory for gun right advocates, Second Amendment advocates. Can we just get a like on this video for this major victory for all of us to be able to protect ourselves, our family, and our property? And folks, I will see you later here on The Bald Brad Show.